Forget the tabloid gossip, there is actual legit law going on behind all of this. Viva Frei, Montreal litigator turned YouTuber, Barney the Vlog Dog right there. I'm doing a car vlog today because one of the children is at play practice and I have some time to kill. The Hunter Biden saga now stretches well beyond the impeachment saga. News broke the other day in a lawsuit over child support that was filed by one Loudon Roberts against Hunter Biden. And the underlying details are the stuff of tabloid journalism dreams. But this channel is not tabloid journalism, and like I always say in law, there is the legal side of the story and there is the human side of the story. Just a brief summary of the underlying facts so that we can appreciate the full context of the motion that was just filed in the child support lawsuit. Hunter Biden has been in the news a lot lately, primarily because he is Joe Biden's son. Joe Biden is running for the Democratic nomination for the presidential candidate, and Hunter Biden has had what some believe to be shady dealings with his involvement in a Ukrainian energy company called Burisma. These business dealings have been one of the core issues in the impeachment inquiry hearings against Donald Trump. I've done a bunch of videos on the impeachment inquiry. I'll link that playlist right here if you want to give it a watch. And if that wasn't enough, he is now back again in the news as a result of having been confirmed via DNA testing to be the father of a child born to a performer at an adults club in Washington, D.C. But we're getting ahead of ourselves, let's just back up a little bit. Hunter Biden was apparently discharged from the U.S. Naval Reserve in 2014 after testing positive for cocaine. Shortly thereafter, his name and address was released in the Ashley Madison hack scandal. In 2016, he left his wife of 22 years, with whom he had 3 daughters, and moved in with his brother's widow. You'll recall that Beau Biden died of brain cancer a few years ago. In the divorce, his wife alleged that he spent money on extravagant things, leaving the family to pay the actual necessary bills. And this week, it was confirmed that Hunter Biden was the father of a child of a performer at the Empire Gentlemen's Club in Washington, D.C. And in those court filings, the mother of the child is apparently suing for $11,000 in legal fees and child support. Recent DNA tests, in fact, confirmed that Hunter Biden is the father, so that there's no more dispute on that issue. And in the context of the request for child support, Hunter Biden obviously has to provide financials so that the court can know what his financial situation is. And that is where the most recent court motion comes into effect. Hunter Biden filed a motion. Apparently, it is a joint motion, that is to say, agreed to between the parties, whereby Hunter Biden's financial information can be kept under seal if so ordered by the court. Now, I always say that in law, there is the legal side, there is the human side, and I don't just say that tongue-in-cheek. Political affiliation aside, we can all appreciate the human side of this story. Humans are fundamentally imperfect. Humans make mistakes. That is what makes humans human. Not only that, but this highlights the risks and perils of living in the public limelight. It's not all fun and games being the child of a prominent politician, not for the child and not for the politician. You know darn well that the media, being what it is and needing the revenue that it needs in order to survive, is just waiting to pounce on mistakes in order to capitalize off the mistakes and errors of others. The bigger they are, the harder they fall, and the bigger story it makes. And so children of politicians and celebrities always live under this limelight, this sort of amplified existence where every mistake they make is amplified by the media. That said, getting discharged from the military for drugs, getting divorced, ending up with your brother's widow, I believe he got married to someone for a very short period of time in between, and then fathering a child to a performer at a gentleman's club, that gives the media something to work with. But what is the law behind Hunter Biden's motion to keep his financial information sealed? It's actually very interesting in law. And reading from the motion itself, which appears in a Daily Mail article, this is what the motion actually alleges. Comes now the defendant, Robert Hunter Biden, by and through his counsel, and for his motion for mutual protective order and incorporated brief, states as follows. So the first thing we learn right off the bat is that this motion is allegedly mutual. That is to say that it is alleged that the plaintiff agrees with this motion, which should in theory give the court a little more lenience in terms of granting the motion, but we'll get there. On or about September 30th, 2019, plaintiff filed a motion for scientific DNA testing, to which defendant agreed. The parties reached an agreement on the protocol and procedure for administering the DNA test, and this testing was completed on or about November 9th, 2019. This matter has been highly publicized, with numerous media outlets contacting the parties' counsel on a continuing basis. Due to the extraordinary circumstances surrounding the parties involved in this matter, it is in the interest of justice and necessary for the court to enter an order of protection to protect the parties' privacy and safety. Paragraph 5. The likelihood that defendants' private financial records, including but not limited to debt, expenditures, and expenses, will be used in an inappropriate and malicious manner for reasons that have absolutely nothing to do with proceedings, is exceedingly high and should not be tolerated by this court. Defendant has conferred with plaintiff in an attempt to reach an agreement on the appropriate scope of the protective order that should govern this matter. While the parties are in agreement that a protective order is necessary and have narrowed the issues in dispute, the parties have been unable to reach a complete agreement despite their best efforts. Alright, on the one hand, this is pretty self-explanatory in that the parties agree that nobody needs to know Hunter Biden's financial information except for the parties parties for the purposes of determining child support. And what Hunter Biden is obviously arguing here is that people want his financial information not necessarily for reasons to determine child support, but for highly political reasons. And he is 1000% correct. So according to the motion, the parties agree in principle but can't agree on the final modalities. The cynical lawyer in me suspects that the parties may very well have arrived at their own mutual quid pro quo as relates to any agreement. This is just the lawyer in me talking, knowing how lawyers negotiate. Oh, you want to keep your financial information protected? Well, it's going to cost you something. But then we get into the actual law. Pursuant to Rule 26C of the Arkansas Rules of Civil Procedure, this court may order that 1. That the discovery not be had, 2. That the discovery may be had only on specified terms and conditions, including a designation of time and place. 3. That the discovery may be had only by a method of discovery other than that selected by the party seeking discovery. 4. That certain matters not be inquired into, or that the scope of the discovery be limited to certain matters. 5. That the discovery be conducted with no one present except persons designated by the court. 6. That a deposition after being sealed be opened only by order of the court. 7. That a trade secret or other confidential research, development, or commercial information not be disclosed or be disclosed only in a designated way. 8. That the parties simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. So the rules of procedure in Arkansas seem to be very similar to the rules of procedure in Quebec. And this was the biggest issue in the Tommy Robinson contempt proceedings. You'll recall that Tommy Robinson was found guilty of contempt for allegedly reporting on a court file for which there was a gag order or a media blackout ordered by the court, meaning that while court proceedings are generally open to the public, in this particular case, an order was put into effect that no one should record on the court proceedings while they were currently underway. And there are a number of reasons for that type of gag order to be issued, one of which is to protect the witnesses, another is to ensure that you can have a fair criminal trial in a matter of such public notoriety that if there were to be contemporaneous reporting, it might otherwise compromise a fair and equitable trial. Agree or disagree with it, that was the rationale in the Tommy Robinson case, and that is oftentimes the rationale when protective orders are put in place by the court. So court files are typically public unless there's a reason to keep them in camera or in private. Youth matters, certain criminal matters, and parties can oftentimes request that certain documents be filed under seal if public disclosure would cause undue harm to the parties. One of the examples actually cited in that allegation was keeping trade secrets confidential. That is to say, business secrets that might give a competitor an unfair advantage, whereas that information would never otherwise be disclosed to one of the competitors. The law provides for certain exceptions where the court can make private what otherwise would be public as a general rule. Incidentally, the fact that certain things become public oftentimes is a negotiating tool in the context of litigation. One can easily imagine a lawsuit between business partners where one business partner might sue another, and if their financial information got disclosed, I don't know, the revenue agency might have something to say about the information that they would find. And it's not just because parties may be prejudiced by public disclosure of documentation that the court can order that they be filed under seal. Under seal, for anyone who's not entirely familiar with the concept, literally means like filed under seal, like in a sealed envelope, kept confidential and only disclosed in a manner that the court deems appropriate. So oftentimes it does happen that if one business partner is going to sue another business partner over certain improprieties in the business, they might hold this over their partner's head like a proverbial sword of Damocles, to the effect that if we go to court and this gets public, the government's going to see what you did, you might get audited, and you might have all sorts of other financial problems. And oftentimes the mere prospect of that is sufficient to bring the parties to the table to discuss negotiation. But like I said, the mere fact that one of the parties may be prejudiced by necessary disclosure of documents in the context of a public court file is not in and of itself necessarily a good reason for the court to order that information to be held confidentially. And a funny anecdote, true story that happened in Montreal. I think it might have been a bankruptcy claim, but it doesn't really make a difference. All that to say is the two parties, by mutual agreement, agreed to file certain documentation under seal or confidentially so that it wouldn't be seen by the general public. And the reason they did this was to avoid certain potentially nefarious financial consequences of that information becoming public. The only problem is that in the context of this mutual agreement, they forgot about a relatively important third party who might have had a financial interest in the consequences of that agreement, that being the government. And when the government finally found out about this deal and then intervened in the file, the judge was none too happy that it looked like the lawyers had pulled a fast one over the judge. Bottom line, it's not just that because it might prejudice one of the parties that the court is going to order the documentation to be filed under seal, and it's not just because the parties agree that the court is necessarily going to authorize that the documents be filed under seal. So what's going to happen in this situation? Because it very much is a double-edged sword. On the one hand, we know darn well that people who have absolutely no interest in the child support aspect of this lawsuit are waiting there frothing at the mouth just to get their hands into this financial information for political purposes. We know darn well that the information can and will be exploited for purely political purposes. So we can easily imagine the hardship that this will necessarily cause to Hunter Biden if this information is filed in a manner that is not confidential. That being said, the flip side, does Hunter Biden get special protections just by virtue of the fact that he is in fact a public figure? Is that to say that Joe Schmo off the street, by virtue of the fact that he's not a politician's son, would have to file this information publicly, but that Biden, who is very much a public political figure, now gets extra protections because of that? The fact that the parties agree to the order might be a strategic decision between the parties. Is it sufficient to override one of the fundamental underpinnings of our legal system, that being the public nature of court files? If the order is granted, are we not very much creating a two-tiered legal system where the rich public political figures get extra protection that the lowly hoi polloi don't? Is granting this order a matter of public concern or a matter of protecting the integrity of the judicial system? Very interesting legal questions above and beyond the otherwise unfortunate human circumstances behind this entire lawsuit. My prediction is that the order is in fact going to be granted, and Hunter Biden's financial information for the purposes of child support is going to be kept confidential. I think a judge is going to conclude that this information need not be made public for the world in order to resolve the dispute at issue. That being said, I also predict that there will be a FOIA request or a motion to unseal, and that the documentation will, in due course, be unsealed and made public. But I think that for the time being, the judge is going to keep this documentation confidential. Let whatever legal battle has to ensue. If anybody else wants to get involved in a lengthy dispute as relates to the release of that information, they can do it in due course, but at the very least, the current litigants can resolve their particular child support dispute, and people can do what they want later on. That is my prediction. We'll see where it goes, and for those of you who might be new to the channel, I should tell you that I am batting 100% as relates to predictions. After having been vindicated in the Nicholas Salmon lawsuit, I will post my vindication video right there if you want to give it a watch. And if you like my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to support the channel, there's a PayPal link, merch links in the pinned comment, and now you know your vlog. Peace out.